And we just heard that that's exactly what the Democrats want to do here today.
Under the new rule, these firearm owners will be required to obtain special registration.
By some counts, so far this year, there have already been 174 mass shootings.
We are the only nation in the industrialized world that tolerates such gruesome statistics.
An independent analysis of financial harm to the firearms industry from the pistol brace ban has been estimated to exceed.
We will have a hearing markup on an assault weapon ban. Their plans and their intentions are clear.
That a lot of the laws we've passed are being rolled back by the federal court.
California law prohibiting arms sales overturned. A California law prohibiting the sales of arms to children was overturned by a U.S. appeals court, stating that it was unlikely to reduce armed crime or the illegal use of such. A panel of the 9th U.S. Circuit Court of Appeals in San Francisco stated that hunting and sports slaying organizations were likely to succeed in their allegations that the statute violates the First Amendment rights to free speech and temporarily halted the law awaiting the conclusion of the case. The court overturned a federal judge in Sacramento's January decision that the statute correctly restricted commercial speech.
Here's a 12-round magazine. This magazine would be banned.
This is an existential crisis that we're experiencing every single day.
By some counts, so far this year, there have already been 174 mass shootings.
They're using the magazine ban to do it. Last year in 2020,
and that the groups had little chance of winning their case. The Ninth Circuit ruled that the state cannot defend the restriction as a means of preventing the illegal use of arms because California permits minors to carry and use handarms under adult supervision. California statute, according to Circuit Judge Kenneth Lee's opinion for the court, does not significantly advance its purported goals and is more extensive than necessary. The Ninth Circuit is one of the more liberal U.S. appellate courts with roughly 30 active judges. The 3 judges on the court, though, were all picks of Republican presidents. Requests for a response from the California Attorney General's office were not promptly fulfilled. In a statement, Chuck Michel, an attorney for the organizations and the leader of the California Rifle and Arm Association, praised the choice. He claimed that this was yet another instance of legislative excess and politicians' readiness to violate fundamental liberties. Democratic California Governor Gavin Newsom enacted the law last year, stating that it was necessary as the U.S. Supreme Court rolls back important armed safety protections. We Won Tactical's advertisement for an AR-15 aimed towards children was used by Newsom's office as evidence that the law was required. Days after the conservative majority U.S. Supreme Court declared that a person's right to carry an arm in public for self-defense is protected by the Second Amendment of the U.S. Constitution, California lawmakers passed the restriction. This decision, which stated that any restrictions on arm ownership had to adhere to the country's historical tradition of arm regulation, prompted judges to invalidate additional arm control measures. California State Legislature in action. Next week is the cutoff date for the California State Legislature to pass bills out of the chamber. With that deadline rapidly approaching, pro-arms state legislators are rushing through even more anti-arm laws. California already has the right to claim that it has the nation's harshest arm control laws. Even now, Governor Gavin Newsom is promoting a constitutional change to eliminate second change rights. Even so, in the final days of the session, they hurried to enact even greater arm control. The final week of bill movement will be chaotic. Here's a summary of recent events in Sacramento. The Assembly approved Senate Bill 241, which is now on its way to the Senate. The legislation mandates annual training sessions for arms sellers and their staff, which are administered by the California Department of Justice. Training requirements include how to recognize and identify straw purchasers and fraudulent activity, how to recognize and identify indicators that an individual intends to use an arm for self-hurt, how to prevent theft or burglary of arms and ammunition, and how to teach consumers rules of arms safety, including but not limited to the safe handling and storage of arms. The arms industry disagrees with the restrictions and fines in the law, but acknowledges that they are crucial elements of owning and running a retail facility for arms. This is why the NSSF supports the Real Solutions Safer Communities campaign.
Here's a Sig Sauer 320. It takes a 20-round magazine.
We've already lost more than 13,000 Americans to gun deaths so far this year.
Earlier this year, the ATF issued a rule that unilaterally puts new restrictions on Second Amendment rights.
We need this 28th Amendment for it.
And what California's gun death rate today is 73% lower than Texas.
And has offered training, information, and resources to members of the industry. Instead of imposing costly and time-consuming regulations on merchants, NSSF offers access to and materials from the Project Child Safe Safe Arms Storage Project, Operation Secure Store Retailer Security Program, and Don't Lie for the Other Guy campaign to decrease illicit straw purchases. Each of these initiatives, along with others, has contributed significantly to making communities safer without burdening small companies with excessive regulations and red tape. Assembly Bill 1406 has been approved by the Senate and Assembly and will soon be signed by Governor Newsom. AB 1406 would add a potential 30-day state waiting period to the current 10-day waiting period for the sale or transfer of a handarm. The current 10-day waiting time is already being contested in court as being unnecessary and infringing on the Second Amendment rights of law-abiding Californians. After all, delayed rights are denied rights. A federal background check window is available for the tiny percentage of NICS checks that return in delay rather than approved or denied, and a successful national instant criminal background check system verification already reveals whether the buyer is prohibited from owning an arm or not. Another law, Senate Law 368, would have an effect on arm merchants and make it more challenging to contribute to reducing the tragedy of arm self-hurt cases. After being approved by the Assembly and Senate, SB 368 is now being sent to Governor Newsom for his signature. If a person dealing with temporary mental health issues decides to give their arm to the dealer for storage, the law adds more regulations and red tape for arm shops to cope with. People are discouraged from choosing this option by laws like those in New York and Massachusetts, and the arm dealer frequently finds themselves in a sticky situation.
High-capacity magazines. I'm going to come back to that in a second.
Every day, more than 100 people in America die from gun violence, and many more.
You know very well what the critics are going to say about this. California has some of the strictest gun laws in the nation.
And don't let them fool you that they are not attempting to take away your ability to purchase handguns.
We are the only nation in the industrialized world that tolerates such gruesome statistics.
When navigating fines and potential infractions as a result of the mandated arm transfers. Assembly Bill 1009 is on its way to Governor Newsom's desk for possible signature after passing both the Assembly and Senate. AB 1089 forbids the manufacture of homemade arms by anybody, including armsmiths and hobbyists, and calls for them to register as state-licensed firearm manufacturers. Building arms at home has been a prevalent practice since the nation was founded. Assembly Bill 28 is among the most heinous pieces of legislation to make substantial progress in Sacramento. AB 28 has already been approved by both chambers and is waiting for a possible signature from Governor Gavin Newsom. With regard to all sales of arms or ammunition, AB 28 would levy an excise tax of 11% on producers and retailers of arms. According to the Associated Press, California's proposed tax would not be applicable to those who purchase arms. Instead, the government would require companies that sell arms and ammunition to pay the tax. To offset the expense of the tax, however, firms typically hike prices. Senate Bill 2 makes it much more difficult for citizens to receive carry permits by introducing a new arbitrary system and requirements for hand-arm permits. Here is Governor Newsom's reaction to the Bruin ruling. He used the same strategy to seek legislation to make it virtually hard for someone to lawfully carry an arm in California, even if they have a permit, since he disagreed with the U.S. Supreme Court's ruling.
I'm proposing the 28th Amendment to the United States Constitution.
They want to take away law-abiding citizens' ability to purchase the firearm of their choice.
An independent analysis of financial harm to the firearms industry from the pistol brace ban has been estimated to exceed
In the filibuster, expand the court, take away your constitutional rights under the Second Amendment. So you can't protect yourself with a 9mm, I guess, according to Biden, only a 22.
Nearly every public space in California would become a sensitive place under the proposed legislation, which would also prohibit law-abiding residents from carrying one. Even though there are still a few days left, the arms industry is keeping an eye on the status of two bills, SB 452, which would require the state to study the ineffective and flawed micro-stamping technology on new firearms in the state, and AB 1587, which would track people who buy arms using credit cards in California. NSSF will keep a close eye on the Sacramento issue. California appeals court overturns law. A federal appeals court said that a California law banning arm advertisements directed at children went too far and should be overturned. Sporting and arm rights organizations, as well as the publisher of a youth slaying mag, had asked for an injunction to prevent the rule from going into force for the time being. They said that this would prevent the promotion of legal arm events and the recruiting of young people for safe and responsible youth sports slaying and hunting programs. That request was dismissed by a lower court. A three-person panel from the 9th U.S. Circuit Court of Appeals, however, overturned that judgment. As a result,
we will have a hearing markup on an assault weapon ban. Their plans and their intentions are clear.
40 million firearms with stabilizing braces currently in circulation.
Well, we just heard that that's exactly what the Democrats want to do here today. Yesterday, Speaker Pelosi, speaking at an anti-gun rally in San Francisco, stated,
the case is returned to the lower court for further review. Last year, the measure was enacted into law. The sale of arm-related products cannot be marketed in a manner that is designed, intended, or reasonably appears to be attractive to minors. The appeal court ruled that the statute does not directly and materially advance California's substantial interests in reducing arm crime and the unlawful use of arms by minors, and was therefore likely to violate the First Amendment right to free expression. The summary of the opinion stated, there was no evidence in the record that a minor in California had ever purchased an arm unlawfully, let alone as a result of an advertisement. Governor Gavin Newsom criticized the decision, citing arm manufacturer advertising for a smaller, lighter version of the AR-15 style that is marketed as being geared towards smaller enthusiasts. In a statement, Newsom claimed that the court is fighting to protect marketing arms of war to children
that are dangerous or felons or don't have weapons, right?
That a lot of the laws we've passed are being rolled back by the federal court.
Under the new rule, these firearm owners will be required to obtain special registration.
In 2021, the Glock 19 was the highest sold handgun in the United States.
It's absolutely insane. Attorney General Rob Bonta and Newsom said they are considering their options for contesting the decision. After the conservative majority U.S. Supreme Court determined that Americans have a right to carry arms in public for self-defense, a significant expansion of arm rights, the Democratic-controlled state legislature passed the law as one of several arm control measures last year. In reaction to mass slayings, like the one that claimed the lives of 19 pupils and 2 instructors at an elementary school in Texas in May 2022, Newsom asked lawmakers to expedite the passage of 4 bills. Jones versus Bonta. In Jones versus Bonta, a divided panel of the 9th Circuit held that California's ban on 18 to 20-year-olds buying rifles is unconstitutional under the Second Amendment.
The Second Amendment protections apply to 18 to 20-year-olds.
Banning a class of weapons that you don't like the look of, not because of functionality.
The decision is a significant win for supporters of arm rights, but its official legal impact might only last for a short while. This case will probably also go en banc, because the 9th Circuit en banc has a tendency to overturn panels that uphold Second Amendment claims. However, the judgment's evaluation of state law is important from an analytical, doctrinal, and jurisprudential perspective. If this case ultimately makes it to the Supreme Court, their actions might have an impact on other courts who are considering Second Amendment challenges as well as the Supreme Court itself. Under this case, 2 statutes are under question. The first bans the purchase of long arms, such as rifles, shot arms, etc., by young adults, those between the ages of 18 and 21, unless they have a hunting license. Certain members of law enforcement and serving and retired military are excluded from that law. One type of long arm, center-fire semi-auto rifles, are fully prohibited from being purchased by young people under the second in question law. Holders of hunting licenses are not exempt from it. However, the same group of law enforcement and military personnel are. These rules do not forbid young adults from owning long arms, including center-fire semi-auto rifles, or from obtaining them legally through means other than outright purchase, such as intra-family transfers, such as a gift from a parent. The state's ban on certain types of arms was implemented in 2019 in response to a Poway synagogue incident, which was carried out by a 19-year-old using a semi-auto rifle.
Well, Mr. Wilcox, there's no law. Congress didn't pass it. That's a rule from ATF.
Second Amendment protects firearms in common use at the time and also said this, quote, for lawful purposes like self-defense.
Young adults are not allowed to purchase arms under a law that was not contested in the litigation, but was discussed by the panel during their examination of the broader system. The challengers' arguments against both the broad long-arm ban and the more specific rifle restriction were rejected by the district court. The court determined that the state prevailed under the first of the two steps of the framework because these laws did not impede Second Amendment protected activity. Alternatively, the trial court decided that the laws would be upheld after applying intermediate scrutiny to each claim. On appeal, Judge Ryan Nelson and Judge Kenneth Lee upheld the decision on the need for a hunting license, but overturned it about the ban on semi-auto arms. In the context of a Second Amendment claim, the Ninth Circuit Court of Appeals examined historical material in depth. The court began by making it clear that despite the fact that the case concerned a rule of commerce, the historical analysis concentrated on the broad development of young adults' right to keep and bear arms, rather than on any particular commercial regulations. It's significant that the court confirmed that owning arms is part of having the right to keep and bear arms. The court identified 5 crucial pieces of historical evidence that helped it come to the judgment that the challenged rule restricted young adults' ability to keep and bear arms. These points included variations in the age of majority and conduct-specific ages across different states, the fact that during the Reconstruction era, most states only regulated handarms and few banned them, the long-standing tradition of young adults keeping and bearing arms in English law and custom.
Our Second Amendment. It's a hell no to government trampling on our freedoms.
But at the crux of this is a bureaucrat making a unilateral decision to try to turn millions of Americans into felons.
The adoption of this tradition by American colonists, the requirement for young adults to serve in the militia and acquire and possess their own arms during the founding era, and more. Ninth Circuit's complex ruling. The impact of California's limitations on the purchase of semi-auto rifles by young adults between the ages of 18 and 20 was the subject of the Jones v. Bonta judgment by the Ninth Circuit Court of Appeals. The court argued that even if these young adults might get these rifles as presents from family members or obtain them through short-term loans, these limitations placed a burden on their Second Amendment rights and made them conditional on the rights of others. The limits were referred to by the court as a ban on semi-auto arms, which prompted severe scrutiny, a more stringent level of judicial review. The Second Amendment was ratified in 1791, and the court's characterization of public safety as a government interest was somewhat ambiguous, implying that arms were hazardous even then, and the government had an interest in promoting public safety. It was unclear, though, if passing arm control laws was in the best interests of the general population. Notable points included the panel's consideration of intermediate scrutiny and its emphasis on the fit requirement.
That you said that all assault weapons should be banned. Is that a fair statement?
Percentage of the shootings were done by semi-automatic weapons or rifles. The number one weapon that they use.
It attacked the cherry-picked formulation of intermediate scrutiny used by the Ninth Circuit, which left out the fit criterion, and asserted that the fit criterion was a crucial component of the intermediate scrutiny test. A law is a good fit for a goal if it regulates only when it helps achieve that objective and does not burden more behavior than is necessary, according to the panel, which referenced the Oxford Dictionary of English in support of its explanation. The Jones v. Bonta judgment included a nuanced interpretation of the Second Amendment, levels of scrutiny, and the classification of limitations as prohibitions. It questioned the significance of public safety in constitutional decision-making and stressed how crucial it is to take the fit criterion into account during the scrutiny procedure. The Jones v. Bonta ruling has created differing conclusions among the judges, demonstrating the intricacy of Second Amendment law. Judge Ryan Nelson and Judge Kenneth Lee wrote the majority ruling, which was very critical of the restriction's heavy burden. The court used statistical analysis to back up its claim that the act was unduly broad. In his concurring opinion, Judge Lee backed the majority's conclusion and presented the problem as a conflict between California law and the Second Amendment's text, customs, and history. District Judge Sidney Stein of New York authored a dissenting opinion in which he criticized the majority for neglecting to take into account crucial factors, such as the disproportionate crimes committed by young adults or their cognitive development.
stripping Americans of constitutional rights won't cure what ails us.
That's what gun control is all about. The ultimate goal is an unarmed and subjugated America.
They use the terminology weapon of war. They intend to ban this class of weapons entirely.
He disputed the labeling of the regulation as a ban and questioned if the Second Amendment actually secured the right to bear arms. The Jones v. Bonta ruling, in conclusion, emphasizes the ongoing complexity and controversy surrounding the Second Amendment rights protected in the U.S., as well as the significance of legal analysis and historical research in determining the outcomes of comparable cases. Federal Appellate Court strike down. According to the Federal Appellate Court decision, California's legislation prohibiting the sale of arms to minors is probably illegal because it violates the First Amendment. For a unanimous three-judge panel of the U.S. Ninth Circuit Court of Appeals, Circuit Judge Kenneth K. Lee wrote that while the ban may be designed to reduce armed crime, the First Amendment requires more than sincere intentions and wishful thinking to support the government's censorship of speech. Lee claimed that California permits children to carry and use arms for hunting and other activities when they are accompanied by an adult, and that the state cannot stifle the First Amendment by permitting minors to do both while outlawing honest marketing regarding those legal uses of arms. The verdict overturned a lower court decision that sided with many pro-arm organizations and rejected their request for a moratorium on the law's application while they used to challenge its legality. Now, the matter has been sent to the lower court for more procedures. It requests a significant victory for armed clubs that work with children, who had contended that the prohibition under Assembly Bill 2571, which became law in 2022, barred them from enticing young members and instructing them on how to safely use arms.
It wasn't a fully automatic gun that was banned in 1986. It wasn't the bump stock.
They were and shot by someone and couldn't defend themselves because their guns were taken from them.
The decision is the most recent in a string of federal court rulings that have started to weaken arm rules around the nation recently, especially in liberal areas like California. The U.S. Supreme Court's revised interpretation of the Second Amendment's right to carry arms, which was the basis for many of those cases, was overruled in favor of the First Amendment last year. California Rifle and Arm Association President and General Counsel Chuck Michel applauded the decision and attributed the ban to Democratic Governor Gavin Newsom. He instructed pro-arm organizations to carry on as if the prohibition had not been lifted until the lower court could act on the appellate court's ruling and issue a new order on the injunction they had asked. The legal team for California, led by Attorney General Rob Bonta, said it was reviewing the decision and will respond appropriately. In an effort to strip this freedom from a generation, Junior Sports Mag Inc. is challenging a California statute that forbade youth-targeted advertising, product placement, and Second Amendment promotion. In order to prevent younger people from growing up ignorant of Second Amendment rights and thereby eroding support for those rights, it was intended to limit information and awareness about such rights. California's intentions were exposed by the Ninth Circuit Court of Appeals, which expressed significant disapproval of the state's conduct. They stressed the need for thorough oversight of legislation like AB 2751, which aims to obliterate a particular point of view from public discourse. A judge from the Ninth Circuit emphasized that California's argument that speech limitations would greatly reduce unlawful arm usage and armed crime among children was supported by supposition rather than facts or evidence.
Maybe 3%, maybe 5%, but we're looking at what could have prevented 90% of the mass shootings.
But, Madam Speaker, guns have been prevalent in the United States of America since before our founding.
The court found that California had not upheld its end of the bargain and emphasized the importance of safeguarding free expression and the access to knowledge, particularly when directed at younger generations. A petition for an injunction was submitted by Junior Sports Mag to stop the new law from taking effect in California. The lower court's decision was significantly overturned by the Ninth Circuit Court of Appeals, which made it quite clear that the judge there had not only erred but done so significantly. The district court's judgment was overturned, and the matter was sent back there with precise instructions. According to the Ninth Circuit Court of Appeals, Junior Sports Mag had a good chance of winning the lawsuit on the merits.
To propose regulations to ban all devices that turn legal weapons into Guns.
Most significant federal gun restrictions in decades on Friday following years of false starts and failures to tighten gun laws.
You are not pursuing an answer because, frankly, you are not grappling with the problem.
Thus, it directed the district court to give the injunction. This situation serves as a warning, demonstrating the lengths to which some states would go in order to sway public opinion and stifle constitutional rights understanding. It emphasizes how crucial it is to safeguard free speech and maintain an open and educated public conversation. That's all for this video, folks. Thank you so much for watching, and we will see you next time.